take the bar and study fully. Right? I've 10 years from now, none of you will remember if you graduated in the fall or spring. None of you will remember. Won't make any difference. You will remember though if you failed. That will be that will severely impede whatever you're trying to do with your life, because that's a full 6 months plus psychological trauma that you're putting yourself on hold. So please stick around today for Chantal. She'll be talking to you about career options, and I'll do the same for at least another day, because I know it's hard for you guys to actually come during the day, so that's why I have her come at night. Okay. All right. I want to do one last run through our beloved diagram on covenants. A couple of you asked me to do this. I'm happy to oblige. So before we move on to the topic of zoning, I want to just do one last run through on this one, okay? When you're thinking about this diagram, the question you have to ask yourself is, when this person wants to this person, what must be present, right? What do you need? And I want to walk through each of the different combinations one at a time. All right, so let's do this. So we start off Amy suing Bob, right? In order for Amy to sue Bob, what must happen? You need either horizontal privity or just contract, right? They can sue under either. That's privy of estate or privy of contract. Either one will work. What if for Amy to sue Carl, right? For Amy to sue Carl, you need two things. Number one, you need horizontal privity. That is privy of estate between Amy and Bob. And you need vertical privity between Bob and Carl. That is, the burden runs down from Bob to Carl. That vertical privity, what do you need? Whatever interest Bob has goes to Carl. Okay. Now what about Diane suing Bob? For Diane to sue Bob, what do you need? Well, the burden has to run down to Diane. I'm sorry, the benefit has to run down to Diane. Do you need horizontal privity for the benefit to run to Diane? Well, not really, right? The reason why is a matter of contract law. Amy can assign her benefit to Dan, and Bob is still bound by the original covenant. So really, you don't need horizontal privity in order for Dan to sue Bob. I think that's a matter of contract law. Everyone with me so far? Okay. Diane. Okay. D. Diane can sue Bob, right? Even if there's no horizontal privity, as a matter of contract law, Amy can assign her benefit to Diane. And Bob is still bound by the original covenant, the original promise. Is that good?
There is Diane's under contract law, and they're going to see damages.
Yes. Yeah. All right. Now, what about Diane suing Carl? Right? In order for Diane to sue Carl, you need a few things. You need three things, actually. First off, what do you need? Horizontal privity between Amy and Bob. Second off, what do you need? You need vertical privity between Bob and Carl. That is, the burden must run down from Bob to Carl. Bob must assign Carl's entire interest on Blackacre. And then you need something else. You need some sort of privity between Amy and Diane. That way, Amy can have the benefit that runs to her. So you can do those three things. Everyone with me? All right, now let's flip it. This is a mutually restrictive covenant, right? It goes on both sides. So let's say Bob wants to sue Amy for violating the covenant. He can do that with either horizontal privity or he can sue in the contract. Let's say Bob wants to sue Diane. Okay, for Bob to sue Diane, what has to happen? You need horizontal privity and vertical privity between Amy and Diane. The burden must run. Okay. And what happens if Carl wants to sue Amy? Right, he can do that either with horizontal privity or as a matter of contract law. Carl can sue Amy. And the last one, Carl sues Diane. In order for Carl to sue Diane, there has to be horizontal privity between Amy and Bob. The burden must run to Diane through vertical privity. And there's some privity between Bob and Carl. Zach.
So, first, I want to confirm that I understand this right. For the burden to run, there must be vertical privity
And
and also horizontal.
correct.
If do I correctly recall your possession does not result in vertical privity?
I think the book said the answer is no.
Is there anything stopping somebody from having someone else strive or possess their property to get a covenant?
Oh, so someone willingly allows someone to squat in their land, get rid of a covenant?
Sure, like suppose,
Well, that's not very hostile, is that? Seems like permissive.
I mean, obviously you wouldn't tell the court that you let them do it.
Right, but even as an objective matter, if you find out wink, wink, nod, nod, it was consensual, then there's no adverse possession.
Okay, so it would be challenging in a practical sense.
Yeah, I don't think that's a proper exercise of adverse possession if it's consensual.
Thank you.
I mean, it's like saying you ask your friend to rob you and steal your wallet, and you put an insurance claim for that wallet, right? That's not going to work. Or like, you have a car and you leave it with the keys on the dashboard in a parking lot for a week with the windows rolled down, and then shocking someone steals you, put for an insurance claim. No, that's not going to work either. All right. So you should be able to do those in your sleep, right? All those relationships I just ran through, you should be able to do those in your sleep. And especially with a mutually restrictive covenant, remember the burden benefits on both sides. They flip. Now, if you look at some of the old exams, it's not with 4 people. There might be 6 or 8 people on these diagrams, and you have to sort of deal with those. All right, but this one you should be able to do cold. Questions? None? You all get covenants? I don't believe you at all. AJ, you had a question for me. Maybe you can just ask it now. I'm sorry I wasn't able to get to it before. Did I cover it?
Bob wants to sue, but Carl wants to sue Amy. He has to have the entire state from Bob.
No. If Carl is suing Amy, he does not need the entire state. He does not need vertical privity. In order for Carl to sue Amy, what do you need? No, you don't even need that. What's the entire point? Okay, let me try this. AJ, for Diane to sue Bob, what has to happen? What do you need? That's not correct. In order for Diane to sue Bob, does she need the benefit or does she need the burden? No. For Diane to sue Bob, does Diane need a benefit or does Diane need a burden? Okay. And how does the benefit go from Amy to Dan? What do you need to have happen? Is that vertical privity? No. What's vertical privity mean? The very definition of vertical privity. We've done this now 3 classes. Check your notes. How do we define vertical privity? For a burden to run, you need to convey the entire estate. If Diane is suing Bob, is she getting the benefit or is she getting the burden? Okay. Do you need vertical privity for benefit to run? No, you don't. What do you need for benefit to run from Amy to Dan? I mean, did you follow a discussion in our last class? We have about 20 minutes on this question. Okay, so I'll try it one more time. In this example, Diane can sue Bob with or without horizontal privity, right? If there is horizontal privity, they've created a real covenant. And the benefit will flow from Amy to Diane if there's any kind of privity between Amy and Diane. Let's say that there's not any horizontal privity. Contract law will fill in the gaps, right? Under contract law, Amy can assign her benefit to Diane. and then Diane steps into Amy's shoes, Amy can then sue Bob.
So any, is that any,
Correct. You do not need vertical privity. So now let's flip it, right? When can Carl sue Amy? You tell me. When can Carl sue Amy?
are we going past the horizontal? Is it
I'm asking you, when can Carl sue Amy?
all- when there's vertical and horizontal privity?
No. Why does it need to be vertical privity?
Oh, well, just horizontal between
You don't even need that.
contract.
So there are two options, right? One option is, give me both options. There are two options. There are two circumstances in which Carl can sue Amy. Two circumstances.
Well, contract. Other services.
I know what you're saying.
You said when Amy can sue Bob.
I'm asking when can Carl sue Amy? That was the question you asked me.
My Carl must have it on Bob.
Okay. What do you call that interest? Privity. So try it again. What must happen? There are two things that can happen for Carl to sue Amy. What are those two things? Okay, so explain. What do you mean by contract? Just spell that out for me.
There is a Amy and Bob that was Bob passed down to Carl.
Good. Yeah. Amy and Bob reached a contract which was assigned to Carl. Okay, what's the second option?
That's what I'm getting on. That's where, yeah. Let's see the contract line. Servitude.
I don't know why you keep saying servitude. How can A and B create a covenant? What must they have? What's the way they create a covenant always in every single case?
At the transfer of the land.
And what do you call that? What do you call that?
Horizontal privity or
Horizontal privity.
that's not a covenant.
I don't know what a covenant state is. That's not
Servitude.
that's not a thing. I'm not sure what you're referring to, right? So you have privity of estate. Is that what you mean? Privity of estate. Okay. So if A and B have horizontal privy, the privy of estate, they've created a covenant. And then what's needed for the benefit to run from B to C? No. Look, I'm sorry. I got to move on. I think you need to rewatch the last couple classes. I'm sorry. No, don't apologize. I'm sure you're not the only one. You have, you can raise your hand, but I think you'll just need to rewatch a couple of the lectures because we've gone over this sufficiently, I think. All right. Are there other questions on this? Okay. All right, let's move on. The rest of the class, we'll be talking about two major concepts, which is zoning and later takings, and they're actually very closely related. Right. So far, we've talked about what you might call a private land use control. So that is a covenant and easement. That is, private parties choose to restrict their land by themselves. The rest of the semester is different. The rest of the semester involves public restrictions on land. That is the government. Whereas the government enacts zoning laws, or the government enacts some sort of a taking where they take or diminish the value of your property, perhaps. Right. Fortunately, or perhaps unfortunately, the last 8 weeks of this class resemble con law. If you like con law, good. If you didn't like con law, well, you have me now, right? No, that wasn't what expecting. It's very con law-ish. In fact, almost everything I'll say going forward is a matter of Supreme Court doctrine. I'm actually thankful that this entire semester we had no Supreme Court case. It makes me happy because they're easy to teach. The Supreme Court's doctrine in this area is a complete mess. Complete mess. The test to decide when there's a taking or not is almost incomprehensible. You'll have to do it. I'll do my best to make sense of it, but it's not easy to work with. All right. Everyone with me? All right. So let's start off with a question that maybe you've thought about, maybe you haven't. I have a follow-up question you haven't thought about. Let's start here. What is the police power? What is police power? All right, another 10 seconds. I know there are more than 14 of you here, so hopefully get people to answer. 26? Yeah. All right. It's about half of you the answer in. All right, there we go. Okay, I'll stop it here. Anyone want to volunteer?
Police powers the state's ability to regulate based on health, safety, welfare, and morals when it comes to all people.
Okay. Can I ask you a follow-up question, please? Where does the police power come from? We didn't have a police power before the Constitution. Where did the police power come from? Anyone?
The ability for the state to pay someone to do violence.
I know what you're saying. Can you tell everyone else what you're saying? Spell it. I know exactly what you're saying, but spell it out for the rest of us.
Police power comes from the state's ability to use force to enforce its laws.
And where does that power come from?
The nature of government.
The nature of government. Where is this nature? What is it? In a park somewhere?
You'd have to ask Hobbes. Dig him up and ask.
I will dig up Hobbes. Okay, I'll dig up lock to level of a seance or something, right? Jacob. We didn't have a 10th Amendment till 1791. Constitution was ratified in 1789. We didn't have a police power before that? Casey. You got nature again, right? What do you mean nature? One, two.
I would disagree with that because at one point it came from a king, like a monarch,
Oh.
right? And so it wasn't the people; it was just.
Ooh. Oh, now we're getting closer. Anthony?
I was going to say it comes from protecting societal norms, values of society. So that shifts on the need for policing or how we police might change as well.
Okay, Mike.
I'm gonna go with social contract.
John Locke?
Yeah, because we're trading our liberty for order, and the tension it creates is the enforcement of that on the government side of the police power.
Uh-huh. So we got Hobbes, we got Locke, we got the king, we got violence. Aaron?
I was gonna kind of go upstream from what Bernie said, say God and his representative on earth.
Which king would that be?
Whichever kingdom you happen to be in, because that's whose police power you are then.
We are under kingdom come, I guess, in this class, right? All right, that's good. Anyone else? All right, so I want to actually work back. Someone said the Constitution. That's usually the answer I get, which is not right, but it's not wrong. We have a Constitution, right? You have your constitutions with you? I gave it to you in the last class. What do you do? Your seat where? Back seat. Okay, these guys got it. Okay, good. I got some fans. All right, come back up if you want one later. Fancy. See, you got one. So look, we have a Constitution, right? And you've all said the 10th Amendment, which has the powers that are not delegated to the federal government or reserved to the people and to the states. But that sort of presumes, what are these federal government powers? Well, we have a Constitution, right, which says Congress has a power to, regulate interstate commerce. Congress can make war, do all these sorts of things. The states can't do those things, but Congress can. Why do we have this system? So let's go back to the king. right? 1776, right? We were colonies subject to the sovereignty of a monarch. The United States declared independence. And if you read the Declaration of Independence, which is in your old book, I promise it's in there, you shift from colonies to states. So the king had this police power, right? He had all this authority. And what happened when the king went away? The power had to go somewhere. It didn't just vanish. It went to the states, right? So truly the basis of whatever police power we have is the king. But let's go back even further. To Hobbes, to Locke, to someone else. The entire basis of our system of government is that we as individuals delegate some power to the government, which allows them to use violence against us if we don't follow the rules. I mean, that's basically what government does. How many cops we have here? Chi and not here, right? But I mean, the reason why you can put handcuffs on someone, right, is not because you're a nice guy or because you're very smart. You're very smart. It's not because you're like that wise. It's because we as a government delegated to the police department the power to enforce the laws, and you can use restrained force when appropriate, right, to enforce that law, right? They teach you this in academy, right?
Yeah.
Yeah, right. Right now, I never actually consented to this regime. None of you all did. We were sort of born into it, but at least in theory, right? If you believe Hobbes and Locke, that we at some point consented to this regime. I never had a vote, right? Maybe I opt out, right? So at some point, the king had this power, and this became the police power, and the states had this power, and we had a early form of government, the Articles of Confederation, right, ratified in 1781, which was an early way of having a centralized government. And the states gave the Articles of Government some powers, not many, not nearly enough. And the Articles of Confederation failed. It was not an effective form of government. Then we have the Constitution. Who ratifies the Constitution? The people of the states, right? At least most of them, some of them at least, right? The purpose of the Constitution did a lot of things, but one of which was to take some of the powers of the states and transfer them exclusively to the federal government, right? Again, commerce, war, foreign policy, and the like. Perhaps it's expanded much from its original design, but there were certain powers that were clearly delegated to the federal government. The 10th Amendment merely reflects whatever is not given to the central government stays with the people. And that is the police power, right? That is the residual authority of our government. And as relevant for this class, the police power includes the authority over property, the authority to zone, the authority to regulate land, authority over marital property. Virtually everything that touches you on a day-to-day basis has residual power in the states. There's only a few things, you know, passport maybe, or you want to mail a letter, right? Go to a post office. But most stuff does, at least in theory, belong to state power. Now, why does any of this matter, right? The police power is broad. As someone said, I think it was Anthony said, it includes the power to regulate the health, safety, welfare, and morals. I don't like the morals part. That's kind of a new one. But at least health, safety, and welfare of the people. Morals is kind of debatable. Okay. This is a very broad power. But there are constraints on this power. Some of the constraints you've learned about, which is the US Constitution. Under the Supremacy Clause, federal law is supreme over state law. If a state police power law violates your freedom of speech or freedom of religion, the state law has no effect, right? You cannot give it effect. One of the other constraints on the police power is the Fifth Amendment takings clause, right? The government regulates your property so much so that it runs afoul of the takings clause. We have a problem. If the government regulates your property and it violates the due process clause of the 14th Amendment, we have a problem, right? So when we talk about zoning and the police power, it's bounded, it's enclosed by the US Constitution, and in particular, the 5th and 14th Amendments. So really, the entire remainder of this class, I'm not joking you, is the 5th and 14th Amendments. That's it. We'll talk about other stuff as well, but that's really the core. The state has their power, that's nice. We also have this federal protection for property rights. Everyone with me so far? All right, so try question number 2, please. Multiple choice. See you guys doing this one. The question is this. The government can deprive you of the value in your property without providing just compensation. True or false? All right, give another 10 seconds. I'll stop it here. All right, so at 60% of you put true, and 40% of you put false. Pretty close. Who here put false? You see? Why'd you put false? Oh, I didn't say taken. Read the question. No, I said deprived value. You put a word that wasn't in there, my friend. It's actually, you made the exact same statement as my student, my first class did it. The word taking is not in there. All I said was deprive of value. Taking value, depriving value, that's not taking the property, is it? So think of the case we have today with the Euclid, right? Did the government deprive Euclid of the value of his property, Ambler? Oh, they did. How much was the land worth as residential versus commercial? This one is actually, yes, sir. So one of the rubs of this class, and in case you just sort of raise this issue, not every deprivation of value is a taking. In fact, there are very complex tests about how much value can be taken away from you before you run afoul of the takings clause. Right. So let's actually look at the Constitution. Let's look at the text. Right. You have it in your pocket. I have it on the screen too for those who don't have it. Right. Yes. Yes. Not every deprivation of value is a taking. Now let's look at the text. Right. Fifth Amendment. Did you do Fifth Amendment in common law? Yes. No. You don't remember? That's fine. Okay, I'll do it again. Yeah, that was what, 3 months ago. I'll leave for my friend from the bar director to come back and talk about that one. No, but it's you won't remember any of this stuff, I promise you. Maybe you'll remember like the stuff about like Locke and Hobbes and violence, but most stuff will just fade from your mind. I know I don't remember most of law school either. Don't ask me about contracts. I have no idea. A little bit maybe. So it says, nor shall private property be taken. That's where the case he put up, right? Taken for public use without just compensation. It doesn't say you can't deprive me of the value of my property. It says taken. So what does it mean to take property? Trust me, we'll have a million cases on this. But at least from the one case we read today, the value of his land was chopped into a quarter, right? 2,500 versus 10 grand. That's a lot of money you're losing right there. And he did not get anything. All right, so now why is this important, right? When we have a police power case, think of it kind of as a binary, right? If the government exercises police power and they deprive you of the value of your property, there's no compensation. Again, if the government exercises police power through regulation and deprives you of the value of your property, there is no need to provide compensation. On the other side, the flip side, right? If the government takes your property, they got to pay up. If there's a taking, as that term is understood in the Fifth Amendment, they need to provide just compensation. So you say, Josh, wait a minute. When is it a taking? When is it a police power? Welcome to Property 2, right? That's the study of that's the object of our study. When is a government regulation a taking? In which case you have to pay. And when is a government regulation an exercise of the police power? You don't have to pay. No. It's a fuzzy line. It's like a pair of slippers, right? It's really fuzzy. It's not a bright line. No, Aaron.
So it's slowly coming back to me through the mist of memory. It's like, what's a taking? wasn't for public use.
Oh, yes, yes, we will do that.
Multi-factor.
Oh, many factors, yeah. But I'm not done yet, right? That's on. Oh, this is a student loan case. It would not be a taking. No, it's not a taking because the government's going to basically compensate them for it, so it's not a taking. But let me frame it like this, right? So again, if there's an exercise of the police power, no compensation is required. If it's a taking, you have to pay compensation. So in every single dispute, you have this sort of conflict, right? Where the property owner says, taking, because I want to get paid, right? And the government says, no, that's not a taking. That's being silly, right? This is a police power exercise. Every single case is like that same question. Think of Euclid, right? In Euclid, the owner of the property, Ambler, said, hey, taking, right? And the government said, no, we're just police powering, right? We're just using our police power to regulate the safety and welfare of the people, so we don't have these parasites crawling around in our apartments. That's bad. So this is very much sort of this fight of whether there's a taking, which requires compensation, or is an exercise of police power, which does not. That's really the rest of the semester in like one sentence. Okay. Questions? Yes, sir.
Is this regardless of whether it's federal or state?
Oh, that's my next question. You stole my next question. Can I get to that? Okay. So I'm sure you all learned about the incorporation doctrine, right? This sound familiar, at least? Incorporation? Yes? No? All right. So the first 8 amendments to the Constitution, not the first 10, the first 8 amendments to the Constitution, as originally designed, only limited federal power. First Amendment begins, Congress shall make no law, right? That's not too controversial. Barron v. Baltimore. Okay. But after the ratification of the 14th Amendment in 1868, things changed. How exactly they changed actually is sort of up for debate, but things changed, right? So at least as originally understood, if the federal government takes private property for public use, it must provide some form of compensation. Okay. What about the states? What happens if the state government takes your property? Well, contrary to common belief, the court never actually incorporated the takings clause. Never happened. Instead, there was a case called Chicago and Burlington Railroad v. Quincy. That's Quincy from the late 1890s or early 1900s, where the court basically said that if a state takes your property, right? If the state deprives you of your property, 14th Amendment, they must provide compensation, right? That the due process of law requires compensation. And indeed, the district court in this case actually sort of echoed that reading. Again, if you read the case, the Quincy case I mentioned, they don't actually say the Fifth Amendment limits the state government. Instead, they say that the due process of law requires compensation if your property is taken or deprived. So a lot of these cases sort of blur the Fifth and 14th Amendment. So to your question, Jose, as a practical matter today, there is no difference whether the federal government takes property or the state government takes property. That is emphatically wrong as a textual matter. It bothers me immensely, but there's no actual difference in the doctrine today. All right. How are we doing so far? Yes, Tamara. Yeah.
State. So the language supports is different. The fifth is just compensation and the 14th is without due process of law. So how does that work? So can the state take it without just compensation too?
Can I ask you a question, please? What is the due process of law?
Hell if I know, I can't remember.
Hell if I know. I like that answer. Hell if I know. Anyone. I promise I'll answer your question. I'll make it back to in a minute or two. Zach.
It's the process that you're due.
That is such a good answer. I love that one. What does that mean?
I have no idea. Nobody comes up with the difference.
What did your prof say in law school?
That's a great question. I don't remember.
Anyone remember what you learned last year?
So would it be like, you gonna have like your day in court?
Procedures, fair procedures. Okay. So let me ask you a question, Giselle, because you're next. I'm sorry. So let's say we decided we're going to change how we have jury trials by flipping a coin, right? So heads, you're guilty, tails, you're innocent. And that's written in a statute book, and that's a statute we adopt. Is that due process of law? Why not?
I mean, at that point, like your life liberty is being determined by chance.
It's
and
fair
not-
though, 50-50.
There's no advocating for.
You can advocate. You can say it's a fair coin.
Jail because the coin is flipped.
But that's the law. You're getting the procedure according to law. The law says you flip a coin, they flipped a fair coin. You got the procedure law prescribed. Mike?
I want to ask a question, but I don't want to yell. Which law are we talking about?
I'm telling you, in this jurisdiction, the law says we're going to try people by coin toss. No, there's no constitution in this country. We repeal the constitution, right? That's what the law says.
Even if that's the case, we want to feel good about it.
To
We
feel
wanna-
good, that's
yeah,
what due process
Well,
means.
Yeah, we want to feel like
James
it's
Brown, right? That feel good?
Yeah, exactly.
You know it would.
You want to feel like it's fair, even if it really isn't. You want to feel like it's fair.
So look, this phrase due process of law, right? What does it actually mean? Now, I think Zach gave me a very good answer. The process that's due to you, right? What process are you owed? But owed according to what? The law, right? Now, my next question will just probably blow your heads up. What is law?
Words. We learned that from words.
So, okay. So the law says we try people for murder by coin toss. Those words. Is that law?
It's the law.
I would disagree with my good friend Professor Ricks.
But that's like saying, one country's due process isn't due process just like when compared to another country. Like,
So we have a country that came from another country. I'm not speaking of other countries. In our legal tradition, which comes from England, we go back to Magna Carta, 1215. This concept of the law of the land, or due process of law, suggests that there is some law greater than whatever's written down. But just because someone wrote down a statute doesn't mean it's actually law. That there's some higher power that a law is subject to, right? And you go law of nature, law of God, whatever you want to call it, right? But there's always some supreme law. There's law over whatever's written down. So anyone ever read the short story, The Lottery? Anyone ever read it? No one? It's kind of. Okay, just cut me some slack, Jack. I haven't heard that one in a while. So let me just give you the summary, and Kirk, tell me if I'm getting it wrong. So the setup is this: you're in some fictional town, and then it's a harvest time, and all the people in the town go to this box, and they all draw a piece of paper from this box, and one of the pieces of paper has a little dot on it, and this one woman draws that she's the mother of a family, and she draws this paper with a dot on it, and then she's stoned to death for the benefit of the harvest. That's the law. It's written down, and she draws this number, draws her lot, and they stone her to death. It was a fair process. Random number draw, everyone drew the same lot, and they stoned her to death. Is that law? So were there written words, Tamara? Oh, there were. But would we say in our conception of law that's law? No, because it's random. It's arbitrary. It's capricious, if you will. And generally, we say when government acts in a random, arbitrary way without any reasoning, it's not law at all. Why do you have a rational basis test? Why is it even a thing? Because there must be some rationality behind every government act, unless that's just random. It's just chance. We cannot have a coin toss jury verdict any more than we can have picking a number of a hat to get stoned to death, right? And this traces all the way back to Magna Carta. So the phrase due process of law suggests that there's some higher power. So to Tamara's excellent question 5 minutes ago, I told you to get back to it, right? Why must there be compensation? There's some higher principle that says if we're taking your property, we got to pay you for it, right? Doesn't that make sense? If I take your thing, I got to pay you for it. Let me give you another one to blow your minds, right? Constitution was ratified what year? 1789. Bill of Rights ratified what year? 1791. If the government took your property in 1790, did they need to pay? I think so. The Bill of Rights didn't actually give us any rights. That's why I hate calling it that. It simply declared what already was. The freedom of speech shall not be violated. Freedom of speech existed before the Constitution was ratified. It existed before 1776. This is a right that existed for a long time, right? These are rights that existed independent of what it was written down, right? That's why we have a Constitution. So as much as I love this document, we didn't really need it. It's helpful to have stuff written down, right? So you don't forget it. In fact, that's one of the biggest objections of the Anti-Federalists. If you write stuff down, people say, oh, these are all the rights, we have no other rights. This is why we have the Ninth Amendment. That their other rights are not enumerated. They're reserved to the people, not incorporated, by the way.
I was actually gonna mention that point about how that was one of the contentions again.
You like common law?
I teach, I'm an eighth grade social studies teacher.
You're a social science teacher. Oh, we got one. Good, good, good. I love those. My favorite ones. History, AP, government. Awesome. Did I screw this up or did that one okay? Yeah, I hate this because I feel like I'm teaching common law, but I sort of have to, right? So to Tamara's excellent question from a few minutes ago, even if we never had a takings clause, right? There might be some general principle that when you take something from someone, you pay them for it. I think we all know that, right? And if the government has to seize property for some public use, they can't do it arbitrarily. They must suffer the consequence and pay compensation for it. If we read Justice Harlan's opinion in the Quincy case, he doesn't even reference a takings clause. He thought as a matter of due process of law, you need to provide compensation when you take someone's property. Did that answer your question, Tamara? Longer answer than you expected, probably. Yes. Right. So this concept of due process of law is very important. It's not just a procedure. You're right, Giselle. It's procedure, but something more than that. Now, you may have learned about substantive due process, which is a very controversial topic, especially post-Dobbs, right? But the idea that there's some law greater that's not just what written down on paper, not just with respect to Professor Rick's words, right? There's something bigger. That's how our system has existed for centuries. All right? Everyone with me? All right. Uh-oh. Yeah.
Yeah, what makes a
Yeah.
right?
What makes a right? Take me for Connell next semester. I don't know. No, I know. I could teach an entire class on this topic. I actually took a seminar in law school on property in the Constitution. That was the entire class. There's some good stuff. I later. Right, what else? All right, let's move on to the topic then, right? Zoning, right? So why do we have zoning? Well, before zoning, the primary means of controlling someone else's land was nuisance, right? Nuisance. If your neighbor was using land in a way you didn't like it, you could bring a nuisance action, but that was very costly, often very time consuming, and also sort of arbitrary, right? You never quite knew if your neighbor was committing a nuisance. And maybe he built a property that you just didn't like, but it wasn't violating nuisance law. So there's no guarantee you even got the remedy you sought. Zoning law really became big in the late 1800s and early 1900s as a way for the government to preemptively restrict property, right? Nuisance law is reactive. With nuisance law, someone does something new and oh my God, you got to sue them to get an injunction to stop it, right? But zoning law is you can't do it in the first place. It's preemptive. And the purpose of zoning law was in part to restrict who can live where. I'm being somewhat facetious, but that's it, right? Who can live where? If there's a certain area that's meant for wealthy people, single family houses, right? You stick the apartments over there by the railroad tracks, right? I'm not being facetious, right? And everyone lives in the right place. So zoning is not exactly how we say an inclusive methodology, right? It might seem like, oh, everyone lives in the right place, but it's quite the opposite, right? You're dictating where people can live based on how you zone the land. And perhaps to no one's surprise, wealthy neighborhoods don't have a lot of space for lower income housing. They just don't create it. We'll do a case later this semester called Mount Laurel from New Jersey. Guess what happens? They make up a right to have affordable housing. and zoning. So we'll get there later. But at least in the earlier days, you didn't have this. Okay. Zoning also had this idea that we need to separate commercial from residential. We don't want people near businesses. In the modern era, we sort of reject that. We like what's called mixed use, right? We have in the first floor, commercial space and apartments above it. That's actually the trend. That's actually what's very popular now. Back then, you had to keep everything very far away, very separated. But there was a problem, right? Was zoning constitutional? Right? Was zoning constitutional? Zoning, without question, deprived people of the value of their property and also dictated how it could be used. And there was a serious concern that zoning laws might actually run afoul of the takings clause of the Constitution. They actually take property. So the Village of Euclid case was a very big deal. Had that case come out differently, we would not have zoning, right? If you imagine if the government had to pay every single person whose property was zoned, they would never do it because it's too darn expensive, right? It just would never happen. So this was a close case. So 6-3 on a fairly conservative court. So it could have very well come out the other way. So let me walk through how. Any questions so far? Excuse me. Let me walk through. Where is it? I have diagrams over here. Okay. Let me walk through. These diagrams are in your they're in your what do you call it? Your case summary, but I have mine here as well. All right. So the idea is to divide property up in different districts. The first district was called a use district, which discusses how it can be used. The second district was known as a height district, which governed how tall things can be. And the third district was called the area or square footage district, which means how many feet you need to have, right? Just keep in mind, the more square feet you have, that means things are further apart and you sprawl out into the exurbs, as we now call them today. It's why Houston's so darn big, because everything's so spread out. But the most complicated one, really the most common one, are the use districts. And I like to think of these as these nested circles. That's how at least I think of it, right? So you have the U1, U2, U3, U4, U5, Euphoria, no, U6, okay? There it is. See if you're paying attention. You're not. Okay. So let's start over here, right? The basis. Let's just erase. Look at that. Here it comes out. The basis of zoning, and I'm not being facetious, is to protect single family homes, right? That's the core premise. If you read this decision, they don't like apartment buildings. They call apartment buildings parasites. Just pretty offensive just for anyone who's ever lived in an apartment building. But the sense was, we don't want poor people living in our neighborhoods and building these high-rise apartments, right? We want them living somewhere else. We don't really care where, but not here. And the zoning was in large part designed to keep people from the cities from moving out. Keep in mind, cars were a new invention, right? But cars allow people to commute, right? Public transit allowed people to commute. And now you can get a bus or a car and actually live in a suburb and go to downtown Cleveland for your job. And this allowed people to live further away from the city. You want to move out from the city, get some fresh air, but you are not finding places for you to live. So in what's called U1, or the first use district, you're limited to single family homes. And relatedly, you have to have a very large acreage, a lot of square feet, which means a lot of dead room around you where no one else can live. There'll be fewer houses per block. There were also constraints on height. That is, your single family home might only be 2 or 2.5 stories, which is kind of like an attic, right? 2 stories plus an attic. So it was limited how much you could actually build. Okay, that's U1. U2, like the band, or I guess the bomber, allow a little bit more. With U2, you could still build a one-family home, right? You can build a one-family home in U6 if you want to. You can build a one-family home anywhere. Not that you might want to, but you could. But in U2, you could build a one-family home or a two-family home, right? This allows more diversity of what you can build, but there will probably be less areas zoned for U2 because it's considered less desirable. Then we have U3. This is the area that's really designed for apartment buildings, right? You could also build 2-family homes or 1-family homes. Now, it should not come as a surprise to you that there are not many U3 zones in most places, right? The apartment buildings are not going to be in the sort of posh real estate area. So what do? You don't live there. That's what you do. Now, at least in the village of Euclid, which is a suburb of Ohio, a suburb of Cleveland, they have mixed, right? U4 is single-family homes, 2-family homes, or apartment buildings, or stores. In a lot of places, you don't even have that. It's only stores. In other words, you can't have stores in the same place as residential. They have to be separate. I'll get to Houston in a few moments. Houston's very unique, that everything's sort of jumbled together. Okay, yes.
Oh, sorry, I'm saying that.
Oh, it is. It is. So I kind of like it. Most people don't. No, but I appreciate driving around and seeing, a store next to a gas station, next to a house in the same block. It's okay. I like it. I like spontaneous order. Okay. U5. I promise I'll talk about Houston in a few moments. U5 is a little bit different. You can also include certain industrial uses, such as factories and warehouses and the like. So again, are you going to be building a lot of 1-family homes by U5? Probably not. And in fact, U5 is usually going to be stuck out in the sort of outer parts of town further from where the people are located. So in theory, at least, you can build an apartment building next to the warehouse and the factory, but it might be quite far away if people actually need to live. And then the final zone to talk about is the U6. And this is sort of like all the above option. Everything can be put there. You see my little spooky gravestone, right? You can put a cemetery there. Was that? Yeah. Is this useful? Yeah. Houston, yeah. So you have the spooky, kind of looks like a ghost face, kind of spooky, right? But you can put the cemetery, you can put the factory, you can put the store, you can put the apartment, you can put the 2-family house, you can put the 1-family house with the partridge and the pear tree. Put everything there, whatever else you want. Let's see if you're paying attention. But this would be the least desirable land because you're not going to want to put a 1-family house next to a sewage dump. You're just not going to want to. Keep in mind, nuisance laws still exist. Someone said, is U6 anarchy? Well, yeah, yes and no, right? You still can't violate nuisance law. There's still environmental law, permitting law. So you can put some stuff there, but not everything. All right. Everyone get the gist of the U6s, 6 U's. I'll tell just a small story just to sort of provide some color for this topic. When I was clerking, I had a case involving zoning, involved a methadone clinic. This was in Western Pennsylvania in about 2009 or so. And back then, we didn't really know about the opiate crisis, but it was very blowing up. And there was a plan to put a methadone clinic for opiate addicts inside of a town in Western Pennsylvania. And they actually purchased a storefront downtown area that was being used to provide this treatment for people. And the town council flipped out and they amended the zoning code, said, well, commercial, but not methadone clinics. So they excluded it. So then they found a spot out in an industrial park on the far side of town, right? Where it was basically U6. You build whatever you want there. So what did the government do? They had an emergency meeting. There always emergency meetings. And I swear to you, there was a strip of grass in front of the methadone clinic. What do you think they did that strip of grass? I want to guess.
Park.
They made it a park. They designated, I'm talking a strip of grass by the sidewalk, a public park.
Like just that strip.
That was it. That was the park. And they designated the public park, and you can't have a methadone clinic within 500 feet of a park. Look, when government wants to act, they act fast. And look, from their perspective, they said we didn't want methadone, basically drug addicts in this community. And I guess the opposite perspective, they're there already, right? It's they're there, and maybe the treatment might be helpful for them. I don't know. I don't know if it's effective. Who knows, right? But zoning is used as a very effective and flexible means of excluding. I can't say either way, right? It sort of sounds cynical, but that's the history of this topic. If they actually look at the notes after this case, there's experience in recent years where even progressives who aren't the biggest on property rights oppose strict zoning. In Minnesota and elsewhere, they see mixed development actually helps people. It actually can bring in more tax revenue and not be so insane that you can pick a strip of grass as a park. The clinic lost in that case. I worked in this case many years ago. The clinic eventually lost because they were violating equal protection. it's really problematic. And they were just acting completely arbitrarily, right? They were legitimately like doing everything they could to keep this one company out of building a methadone clinic. Okay. All right. Yes.
So I was gonna ask, like, in that type of scenario where it's like the government kind of acting and making all these rules just to like kind of keep that one clinic out, like when is it like, okay, that's too far for the government? Like when is it like government overreach?
And now you're talking about language, right? Um, so this part of it is just vindictive, right? If there's evidence the government's taking action for you and you alone, that could actually be retaliation, violation of due process. There's some case law on that. But here there's actually an equal protection issue where they're basically acting irrationally, right? You have the rational basis test. This is completely irrational. There's no reason why a strip of grass in an industrial park would be considered a public park, right? It's just to say it out loud to realize how insane it is, right? There are no kids playing there. There's no swing. There's no playground. This is done just to punish one company, and that's a violation of due process. Some precedent on that. Okay. I always sort of raise that example to illustrate zoning can just be used in wacky ways, right? But again, I mean, but going back to Talia's point, she likes zoning. It makes things look pretty, right? So there are upshots. I don't want to say that there aren't, um, but there are downsides as well. All right. Does anybody want to give me the facts in the Euclid? Go to Euclid, the Ambler. Anyone give me the facts? He's not here, my friend. No one. Brian. Oh, okay, good. Go for it. Did you say what? What'd you-
So the appellee was Ambler Realty. They owned the tract of land about 60 acres. And it was situated in the west part of the village.
Euclid, yeah.
This area seemed like it was surrounded by restricted plats. So pretty much all around it was almost like master community plans, or at least restricted plans, so you could have certain things there. But they designated that land for commercial or industrial. So they eventually brought an action by agreeing if they have to build residential houses on the property, their value will get cut by about 75%. As we talked about earlier, $10,000 value of land that was reduced down to 25,000.
Okay, very good. Thank you so much, Brian. Appreciate that. So we have this plot of land, which is in Euclid. Again, Euclid is a suburb of Cleveland. And it's actually a perfectly named case. You might remember from geometry, Euclid was the father of modern geometry. Euclidean geometry, ring a bell? No? Okay, my teacher knows it, right? You remember Euclid, right? Oh, yeah, whatever. I mean, okay, fine. Euclidean geometry, that much I remember. And so you have this plot. On one side, it's bounded by the railroad. On the other side, it's bounded by a very busy thoroughfare. And the government sliced it up, right? Right next to the street, they put the U2, which again is a two-family home. In the middle of this little bitty strip, which is pretty narrow, which is U3 for apartments. And then by the railroad tracks, you have there's a huge slot for U6. Now, does this make sense to anyone? Why on earth you would do this? Zach?
Denser populations are generally lower socioeconomic status, and people of lower socioeconomic status are more likely to work in industry.
So you want to put the poor people near the factory? I think that's what you said. The problem with this, though, is what you can build and what you can't build, right? The land that's zone U3 is probably so narrow, it's unlikely you can actually even build an apartment building. And even if you could, it's directly, immediately next to waste product. And it's also very unlikely that you build two-family housing right next to the industrial park, right, without even streets between them. So you might say, well, Josh, isn't this map just completely irrational, arbitrary, like picking a number of a hat, or like drawing a piece of paper that you get a judgment based on which number you draw? This is not a as applied challenge. This is a facial challenge. You know the difference? Okay. In constitutional law, there are two types of ways you can challenge a law. The first approach is saying, as applied to me, this map that you drew on my property is irrational. It's unconstitutional, right? That's called an as applied challenge. But Ambler Realty did not bring an as applied challenge here. They didn't want to. They wanted the whole kit and caboodle. They brought what's called a facial challenge. That is, they challenged the entire city zoning code on its face. U1 through U6, A1, A2, A3, H1, H1, HB, H1B, no, H1, H2, H3, right? They challenged the entire thing on its face. So the court really had no occasion to decide if this particular map was unconstitutional. All the court would decide is if in the abstract, the full policy is invalid. Right, everyone with me? Ultimately, the court says that no, this policy is fine, right? And I want to walk you through, please, the court's analysis here, right? So first off, the court takes a very broad conception of the police power, right? It wasn't a given that zoning was within the police power, right? U1, U2, U3, U6, and so on. None of these properties were inherently dangerous, right? Having a one-family home next to an apartment building wasn't actually danger. It wasn't a nuisance. It wasn't actually harming anyone. At most, what you would see is people who probably have less money than you living next door, right? If there's crime, then you can remediate the crime. But really, on its face, it's saying we do not want people of different socioeconomic status living near each other. I can't say any more bluntly than that. That's what was going on here, right? It's not a given that the police power includes separating people by wealth. That's not automatic. But if you take a broad conception of welfare, right? Health, safety, welfare, take a broad conception of welfare, you can do it. Now, the reasons they gave were not poor people. The reason they said, well, we want to have peace and quiet. So I guess you can say having more people living in a smaller space will create more peace and quiet. But having people live there doesn't automatically mean you have a nuisance. They have noisy things, right? So we're sort of making presumptions. But again, the court took this broad conception of the police power that allows, right? That allows separate and space to exist. Okay. So the court says that the zoning law did not deprive Ambler of liberty and property without due process of law. Now, did it deprive him of value? Absolutely. The acreage went from 10,000 to 2,500 per square foot, right? So there's definitely deprivation of value, but that deprivation of value is not enough. Okay. And the court uses a lot of deference language. So if you remember from Lochner case, which was not necessarily wrong, maybe you learned it was, but I'm on the fence, right? The evil Lochner, ooh, right? The court says we will only declare the law unconstitutional if it was clearly arbitrary and unreasonable, having no substantial relation to the public health, safety, morals, or general welfare. This sounds like Justice Holmes's dissent in Lochner, if I can draw the analogy, right? It's one of deference. You listen to the Democratic branches unless it's clearly unconstitutional. The court said if it's even debatable, right? You can debate whether it's good or bad, government wins. Right? If there are even legitimate arguments on both sides, doesn't matter which side's stronger, you simply defer. Then the court goes through some of the policy considerations to support the ordinance. For example, you increase safety and security. It's not entirely clear how you do that by separating people from people, but you can do it. Preventing street accidents and reducing traffic. I mean, I'm sure there are other ways to reduce street accidents, traffic, having traffic lights, signals, and the like, but that's not what the court's doing. They're not going to decide this or that, right? If it's within the realm of possibility, the government will win. And then we get to this idea of apartments as parasites. And that's where we sort of like to give away the game, right? That's when you realize those up to traffic safety is not really what they're talking about. That's just sort of a window dressing, if you will, right? What they're really worried about is people living in their neighborhoods and they want to keep them out. That's bluntly put what we're talking about here. And the court says, like a pig in a parlor versus the penthouse, these apartment buildings are out of place. And look, where they put U3 for apartments? Right next to the industrial, with this little bitty strip that probably couldn't fit in an apartment building. Okay? So in the end, the court says the village's zoning ordinance was constitutional and a valid exercise of authority. All right, questions on Euclid? Had Euclid come out the other way, zoning would not exist because again, the government couldn't afford to pay. Right, this was the make or break moment for the zoning. There's a fascinating story at the end involving Chief Justice Taft in a brief. It's good. It's a good read. But this is I'm often asked, probably the most important property case of the 20th century is Euclid. If this one came the other way, our country would look very different. We could be Houston everywhere. Talia saying no. All right, questions on Euclid? All right, let me talk a bit now about Houston. I keep sort of teasing it. So it's often said Houston has no zoning, and that's correct as far as it goes, right? But it's not the full story. Houston does not have use zoning, right? Which is why you can drive around the Galleria and have, like, basically a mall next to a gas station, next to a house, next to a adult bookstore, which I know is gone. They moved that one, right? Yeah, and then now it's on I-10. They moved it. But I remember my parents first came to Houston. They stayed by the Galleria. I love this story. My dad said, "Oh, we can just walk around." Like, no, you can't. And they want to cross Westheimer by 610. I'm like, don't do it, Dad. The street's like 25 lanes. They have to basically run across the street, right? But why does Houston look the way it does? It's the product of our lack of a zoning code. So even though we don't have a zoning code, we have minimum lot sizes. At least we used to, which means lots have to be a certain size. What does that mean? Fewer houses per block means everything spreads out. So the sprawl, if you will, in Houston is directly related to the fact that lot sizes have to be very large. Also, since we have so many cars, roads have to be very wide. I don't know if you ever noticed, but the roads in Houston are wider than any other city in the country. Like when I go home to New York, I feel like I'm being strangled in the lanes because you have so little room between cars. In Houston, it's like, oh man, I can do this. You get to swerve a little bit, it's no big deal, right? I feel kind of at home. It's comfy. You remember the Seinfeld where Kramer started to change the pavement? He tried to remember that one. He was painting over the lanes to have people have more room. Anyway, yeah, in New York the lanes are very small. So what happens when you have very large lot sizes and very large streets? You get no sidewalks. So the reasons why Houston has no sidewalks is there's no space for them, right? Because the houses come right up to the curb, and then you got a big wide street, and there's nowhere to walk. So in many regards, Houston's lack of walkability is there. Maybe the Heights and maybe Montrose, a few other places you can walk around, but those are the outliers. The other way in which Houston does sort of zone, but not really, is through deed restrictions. So you've sort of driven around, you see signs saying this is a deed restricted community, right? You've seen that? You've not seen these signs? Well, why are those there? Put people on notice, right? You cannot live in this neighborhood without having actual notice of a deed restriction. So the servitude is going to be forced against everyone. That's why those signs. Now you know, right? Now you know. And what's unique about Houston is that the city attorney, right, the Houston city attorney can enforce a covenant. So even if the neighbors who have the dominant tenements don't enforce it, the government will. And that's actually how a lot of the Ashby land was litigated. There's no covenants there, but the city attorney, tried to maybe intervene and perhaps block the construction. Houston does not have zoning, but they sort of do. So the upshot is you have large lots, you have wide streets, you have sort of very small sidewalks, and a very eclectic assembly of businesses and homes on the same block. Casey. I'm sorry, say it again. Yeah, that's in the book too, right? The book discusses this. I mean, thankfully, the lack of zoning keeps property values cheaper here, which makes it easier to buy homes. I mean, I tell my friends in other cities, if I pay for my house, they don't believe me, right? It's true. Construction's easier because you don't need to go through the zoning process. The Ashby situation I mentioned was so egregious precisely because of how much time and money it took. Right? That's why the construction industry fought it so hard. They didn't want to just give in to the neighbors. That's why the neighbors fought so hard. Also, they didn't want to allow this precedent to be built.
Have they decided what they're gonna do with that location?
I don't know. You told me that they're going to start building, and I tried finding more. I couldn't find anything.
I think I read something,
That was in 2022. It was a year ago.
they're gonna put some low income houses.
I don't know. It's funny. I actually checked my lecture notes. I wrote, I swear to you, construction will begin in 2014. That was my lecture notes from I don't know how many years ago. And that was, I haven't deleted that line. I just leave it there for you to remind me of how insane this is. Yeah, sometimes I leave notes to future Josh and I come back to it later. For the next time I teach the class, I do common law. I was like, this case might be overruled next semester. I just put a little note there. All right. So again, Houston doesn't have formal zoning, but they have something approaching zoning. And Professor Matt Festa, who teaches here, is perhaps one of the experts in the world on this issue. We also have what are called historical districts. This is a big issue in the Heights and elsewhere, where they designate historical districts, not historical building, that a building has historical value, but an entire area. And that's simply just a way to do what I call backdoor zoning. It's zoning without calling it that. And Fest had a case up at the Texas Supreme Court last year challenging it. It didn't resolve entirely, so there'll be more litigation about it as well. All right, any questions on Houston? All right. There are a few other points I want to make. I'll let you out a few minutes early, but you have to come back. Don't bail me. It'll make me look bad if you don't come back for the career person. I'm serious. She didn't have to be here tonight. She has kids and stuff, so just make her time valuable. The structure of zoning starts at the state, right? When we say the police power in our system of government, the states have all the power. How then can Houston zone? Houston can zone through what's called a delegation, right? The law is called the enabling legislation, or the state zoning enabling act, right? Enabling. What the Enabling Act does is it gives the state the power. I'm sorry, the state gives the city the power to zone, right? You may not think about this, but what is Houston, right? What is Dallas? What is Austin? What is San Antonio? These are cities. Cities are created by the states as charters, to corporations, basically. If tomorrow the Texas legislature wants to abolish Houston, they could. They want to abolish Austin and make it just an enclave of the state government. They could do that, right? Cities exist at the pleasure of the state. Any city law that violates state law is preempted, the same way that a state law is preempted by federal law. Preemption works in the same way. If you take Professor Rhodes' class in state common law, you'll discuss this in depth. Right? Why does this matter? If the state enacts a zoning code that says you can do X, Y, and Z, but the city does something else, right? They do A, B, and C, that's not valid. It's what's called ultra vires. ULTRAVARES, ultra vires. Ultra vires is a Latin phrase that means beyond the scope of authority. And our readings for next class will talk a lot about what happens when the government acts ultra vires, beyond the scope of their authority. Okay. For example, let's say the state says you can regulate uses in area but not height, and then the city starts regulating height. Well, that goes beyond the scope of delegated authority. That is invalid. Let's say that the state says you're allowed to grant a variance in situations X, Y, and Z, and they don't grant in situation X. They're ultra vires. They have to follow state law, right? Local governments, local zoning boards cannot exceed state law. Now you might ask, who actually enforces zoning codes? Well, the answer is generally not elected officials. Usually every city has a planning commission who are usually appointed by the mayor or other executive. Right, so they're not elected, should not be accountable, and they can sort of do what they want, subject to some litigation. What about if you don't like what a zoning board does? We'll discuss there's something called the Board of Zoning Appeals, the Board of Zoning Appeals, or the Zoning Board of Appeals, called different things in different places. This board can grant variances, they can grant special exceptions. We'll talk about these. But again, these are generally not elected officials. They're usually appointed, and they usually serve their terms. And if you don't like what they do, the answer is usually too bad. Now you can go to court and sue on it, But those are often very time consuming and expensive.
How long can a city fight the state when they overrule their zoning? Like in California right now, there's all this. Basically, the governor passed this thing where you can't do single family by mass transit, and like I know the city of Long Beach and LA is. They're basically this. They've created these mandates for affordable housing, and all the cities are like suing. So how long can they oppose what the state government has decided? Because they're blocking like the application.
I'm not sure I understand your question. Who's blocking whom?
The city.
The city is preventing state law from being enforced?
Yes.
Well, that's not supposed to happen. So, I mean, I suppose the governor can go, or the attorney general can go to court and seek an injunction against the city, and then the city can be held in contempt of court and assess fines and even jail time. Generally, cities can't ignore states. All right. So if you're reading for next class, you'll have cases where the state is going beyond the scope of their delegated authority. Again, it's called ultra vires, ULTRAVIRES, ultra vires. Okay. The last thing I want to talk about, I'll let you out a few minutes early, and please do come back, is what's called a comprehensive plan. Right? Comprehensive plan. When the government zones, they're not supposed to act arbitrarily. Right? They have to have some cohesive master plan of what they're doing. This sort of thing makes no sense. Right? Makes no sense whatsoever. Completely arbitrary. You say, wait, Josh, how is this consistent with the master plan? The sad truth is that comprehensive plans are usually not very comprehensive, and they're not really planning, right? Governments have wide latitude to sort of pick and choose, develop things as they go along, try things out, change, etc. So zoning boards have vast amounts of discretion, and under Euclid, there's very little ground to challenge them in court. There's a lot of deference that goes on. Okay, questions on that? All right, let me wrap up. Please do come back in about 10 minutes. Let me turn the polling question on. Just as we leave, a few things to keep in mind. When we're talking about the Constitution, we have to ask ourselves, if there's an exercise of the police power, no compensation is required. If we have a taking of property, you must use the compensation, right? You must fight compensation. The fight always is between the property owner and the government. The government says, police power, and the property owner says, taking, and then that's the rest of the semester. That's true. All right, I'll see you back. It's true. In about 9 minutes. Thank you all very much. I hope you can enjoy it. Thank you. As long as you want to go.